Honorable Chief Justice and Associate Justices, may it please the court. The issue before this court is this. In a death by auto case in which the state charges that the defendant's reckless driving caused an auto accident that in turn caused the death of the alleged victim, does it matter that the alleged victim actually did not die as a result of the accident? Defendant contends that it does. The state contends that it does not. In this case, the defendant's experts, Dr. Palomeni and Dr. Velez, each have submitted a report in which they opined as follows. Dr. Palomeni opined that the death was a result of the very potent narcotics administered under auspices of palliative care. He opined that the injuries were not life-threatening and that the death was a natural cause of death. Dr. Velez opined that this isn't opined, this is factual, that the vital signs remained stable until opioid dosages were escalated at the wishes of the family. The severe pain that she came in with was adequately controlled by the opioids and that the vitals remained stable. The lung contusion was not supported by the autopsy and the hospital course, and that she would have survived the injuries. However, the state asks this court to interpret the Penal Code's causation statute so as to prevent the jury from learning the opinions of these two doctors. The defendant submits that it would be absurd and unconscionable to construe the Penal Code so as to disallow proof of a defendant's actual innocence. Defendant's position has already been adopted by this state in State versus Martin. And as this court is aware, in Martin, the issue was an arson. And the convictions of murder and felony murder were both overturned by this court. The murder conviction was overturned because there was a question, at least for the jury to determine whether the actual harm was the probable consequence of the defendant's actions. And the felony murder conviction was overturned because there was a question of whether the death was too remote, accidental in its occurrence, or too dependent on another's volitional act. And in that case, there was a question of an arson and whether there was where the kerosene was, whether the victim falling asleep after drinking contributed, and the size of the fire and the purpose of the fire. Indeed, in this case, either the state is right or this court was wrong in Martin. Now, the state's position in this case is also contrary to the ALI's Penal Code's, MPC's understanding of the causation statute. As explained by, as set forth in the public defender's brief, whether, for instance, someone attempted to shoot his wife, no one would think that the defendant should be held guilty of murder, though he did intend his wife's death, and his attempt to kill her was a but-for cause of her encounter. And using the horse hypothetical in the commentary to the MPCs, which was if someone were to shoot at his wife, and let's say she, as a result, took shelter at on her father's farm, and while there fell off a horse and died.
So and here I understand the state to be arguing that Ms. Melee needed to be put on a ventilator because of the catastrophic injuries that she sustained in the crash, and that it was her right to decline to be put on a ventilator, and that she did do so.
Now, the the records do not support that there was ever a necessity for the ventilator until after her breathing started to falter, after the increase in the opioids, after the choice for palliative care was made.
Can you
So
tell
that's-
us where to find that in the record?
Correct.
It was, got that picture. I just dropped that page. On the appendix at page 369 at 11:23 p.m., it says that they reviewed and validated by patient order given for DNR and DNI. And and it's mentioned that she has an advanced directive. And it says okay, on the general information, it says that the reason for hospitalization, according to their family, is hospitalized more than one time for the same condition in the last 3 months. So.
How does that answer that question?
No, I agree, but
Agree with what?
no, I agree that it doesn't necessarily, I was just reading the record, but the point is, there is nothing in the record that
Just,
supports.
let's pause on that issue. Is that the page that you're telling us establishes that she needed to be put on a ventilator only after the morphine was administered?
That is, that is according to the opinion of Dr. Velez, relying on the medical records. So in his
It
interpretation,
seems like, sorry, it seems like there's a factual question of, did she need to be put on a ventilator before or after she was given these increased doses of narcotics? And I understood from your brief and argument that you were arguing that she did not need to be put on a ventilator or decline being put on a ventilator until after these increased doses of narcotics were given. And it was a result of the increasing doses of narcotics. However, I understood from the state during their argument that that's factually incorrect and that it was her injuries that caused her to need to be put on a ventilator, and she had every right to decline that. So where in the record can we answer that question?
Your Honor, in the record, there is, from what I recall, there was nothing pre-morphine or pre-palliative care about ever needing to be on a ventilator. There
So
was,
are you saying that the record of 369, 11:23 PM was after there was the increased doses of morphine that were administered? Because that's contrary to the sequence of events that the state has recounted.
if I'm correct, Your Honor, and if this was approximately 11:30 at night where this conversation, where they reviewed the DNR.
Okay.
And at that
And
point,
when is the morphine administered? Because what you told us was that the state was wrong, factually wrong, and that she was only given, or the issue with respect to the need for intubation only arose after the administration of morphine. And you said that we should look to 369.
yes, and that's in the hospital record. That's a record from the hospital.
Yeah, but it doesn't,
When was she given the morphine?
Well, let me just check.
And if you could, as you give us page sites, is it whose appendix is it you're referring to?
I'm just pulling up the report of Dr. Velez. I know he at 1700 hours, she was receiving a morphine sulfate drip of 2 milligrams per hour.
Sorry, that's June 4th at 5 PM. That's 1700.
June 5th at 1700.
So I think we're talking about
2 different days.
Oh, the night before.
That's right around the time she died, that last
Yes, yes,
reference.
Counsel, as much as we'd like to have the answer to this question based on the earlier argument, I don't know that it's productive use of time.
Yes. And I know it's on page 308 or their appendix at 308 where he goes through the time.
State's appendix 308?
Yes.
This is the expert report.
Yes, of Dr. Velez, he goes through a chronology of events. So just trying to find the exact line in there.
So if we were to just discover from the factual record that she needed to be put on a ventilator because of catastrophic injuries suffered during the crash, then would you still have an argument?
Yes, and to distinguish this from Pelham, because in Pelham, someone was removed from event. And at that point, when I'm going to use the term pull the plug, you know what the result is going to be. The body at that point cannot sustain life. In this case, there's question of whether or not the body, Miss Millie's body, could have sustained life as a result of the actual injuries from the accident. And I think that's the distinction.
How, if she needed to be put on a ventilator because of injuries sustained in the accident?
But
And it's her right to say no to that.
But could she have, now with the event, would she have recovered? Would her broken ribs have, would the broken ribs have been able to heal? Or with the ventilator, would it have just been easier to heal? Or is this a situation where you're putting someone in I'm just gonna use the term like an, induced coma so that the body can recover in a more comfortable state? But the question is, what would the body have recovered from the broken ribs? And what would
That seems to bring up another factual dispute where you said there were only 3 broken ribs, but the state says there were dozens of broken ribs.
Yes, Your Honor, I know our experts put 3 broken ribs. There's say 12, if I'm correct, the medical records said 3 broken ribs, and there might have been and there may have been a discrepancy in the autopsy versus the medical records. But if I'm correct, the medical records themselves said 3 broken ribs.
Counsel read to us a recitation that sounded like there were multiple fractures on individual ribs.
Right, and I believe that was the autopsy report, not the medical records. So what may have been seen and interpreted by the treating doctors may have been different than what they saw when they actually did the autopsy, much like how there was difference in what they interpreted with the lungs versus what was seen in the lungs.
But how does that help you if it turned out that she had all of these catastrophic fractures that made her lungs collapse? How does that help your case?
But there's nothing in the record or in the medical records that support that her lungs were collapsing or that she would not have recovered from the injuries. And at the very least, Your Honor, this would be a factual dispute for the jury.
So you're saying you think there's a discrepancy between the medical records and the autopsy report? So the autopsy report is incorrect in stating that there were multiple rib fractures?
Well, if I'm also correct, there was possible bruising of the lungs noted in the medical records by the treating physicians. And then when they actually looked at the lungs, there was no bruising of the lungs when in the autopsy. So the way that what was seen in the ER and in the ICU may have been different than what was actually seen. For instance, Your Honor, they didn't know that there was cirrhosis of the liver and that the drugs would have had a different effect on the person. But again, at that point when they started, there was already a decision made where they were giving huge amounts of morphine and Dilaudid. So I think at that point there was already a decision made. So I don't think the cirrhosis really factored in. But even if it probably just sped up the chain of events that was inevitable. So
Your point is there's a distinction between intubating if it's temporary for purposes of facilitating recovery, or if it's more long-term because a patient simply cannot and is not expected to sustain the capacity of themselves to breathe.
yes, Your Honor, and to some of the points that Your Honor was making earlier, someone goes to the hospital for a broken arm, broken leg, and what is the culpability of a defendant? Is it, and this could be the difference between an aggravated assault or an assault by auto and a vehicular homicide, where where the actual injury is something that someone could recover from. But then it becomes a vehicular homicide because of decisions made at the hospital. And this is why this is a prong 2, because in the prong 1 cases like Buckley, that the person was unresponsive at the scene, brought to the hospital, and there was a 38-minute time frame between the accident and when the person was pronounced dead at Robert Wood. So this is not,
Disagree that the state has the right to choose whether or not to prosecute under prong one and or prong two, even though we explicitly said that in Buckley.
Your Honor, I think the facts dictate how a case is prosecuted and the facts dictate how a case is defended. And the facts dictate the evidence at trial, and the facts at trial dictate the jury charge. And the state is trying to, before trial, dictate the evidence and dictate the jury charge and use that as a way to avoid the defense from putting on their case. In the way that they would prosecute it, would the medical examiner even need to testify? I've never had a homicide case where the medical examiner did not testify. And one of the things that a medical examiner always testifies to is the cause of death, no matter how obvious it is. In this case, the states of the position, they even said earlier this morning that they have no experts. But a medical examiner, I've never had a case where the medical examiner is not qualified as an expert.
If we disagree with you and we hold that based on Buckley, the state gets to choose whether it's relying on prong one or prong two. Is the state correct that you do not have any argument as to prong one?
Your Honor, that's, again, because would we, I think there would be also an issue with the jury charge on that, because was this the type of, was this the type of death that you would see?
That's not prong one language.
Would you concede that if a person drives at a fast speed in the opposite direction of the traffic, that gives rise to a risk of a fatal motor injury? Fatal motor vehicle injury within the risk of which the actor is aware?
Yes. However, as it pertains to this case, the question here is, was this a fatal accident? And the reason I mentioned that is to use Your Honor's hypo. If someone drives in the opposite lane of traffic at a high speed and the only injury is a broken leg, the conduct is the same, the culpability is the same, the injury is the difference. So in Your Honor's hypo, that person would have driven with the same culpability as the defendant in Buckley, but could not have been prosecuted for vehicular homicide, despite
Because the person didn't die.
Right.
So there would be a different charge, a lesser charge, and there would be a jury charge regarding whether or not that was within the risk was within the risk that would be expected, that particular level of injury, depending on what they charged that person
Right.
with.
And my point is that we have same conduct, different result. And because of that, we have, same mens rea, same recklessness.
But that's just the criminal law. I mean, you agree that if the exact same hypothetical happened and the person dies in the car at the scene, then they can be charged with vehicular homicide, even though if the person didn't die and only had an arm injury, they couldn't be, correct?
Yes. And I think
What is the argument? Just to go back one step, do you have any argument on prong one? Or if we agree with the state that they can choose prong one or prong two, you have no argument as to prong one?
Your Honor, I don't think that's prong one, because that the risk is, if you're using fatal accident as the barometer, whether his conduct caused fatal accident, I think there's still question under prong one of whether this was a fatal accident.
That's
Okay,
not,
so then you're saying that you are arguing that the actual risk was not within the risk of which the actor is aware, because he could not have known that I'm not going to use the language you use in your briefs, but we know the argument
Right.
as to what you're saying.
And I think we end up at the same point, because our point is that this was not a fatal accident, that she died as a result of something else other than the accident, which is essentially the same as a prong two analysis of whether it was too remote. And I think that there's question of whether this was in fact a fatal accident.
so
And
there's no difference in your mind whether between prong one and prong two?
there is, however, prong one, when we think of the typical fatal accident, we think of a situation where there's no question that the death was a result of the accident, such as in Buckley, where the person died, was never responsive. It was almost a dead on arrival, and I think that's what, I think, and I know Your Honor,
You don't, but you don't think that prong one can apply to a situation where someone lives on, is treated for days or potentially weeks?
it could.
This is a one-day event, right?
Well, that's
A day and a
Pelham.
half later.
That's essentially Pelham. And I think that, and that's why as I stated earlier, the facts dictate the case. In Pelham, there was no question. She was put on a ventilator as a result of the accident. And in Pelham, the intervening cause is defined as whether or not it interrupted with the natural cause of things. So in Pelham, that was the natural cause of things. In this case, there's question about what the natural cause of things is.
Are you saying that that intervening cause provides for the defense an opportunity to force the state's course of proving their case into prong two?
Again, I think that just as I said, that the facts dictate. I think in this case, prong two is applicable because there is a question of whether or not it was a fatal accident. So I don't know.
I think prong one is inapplicable to cases such as this, in which there's not an immediate death, a death the next day.
I think when there's a question of whether or not it was a fatal accident. And maybe we're saying the same thing different ways, but in a case where there's question of whether it's a fatal accident.
Well, the state is alleging that the actual result is death. And the question on prong one is it was death within the risk of which the actor is aware. And the conduct at issue is as described in terms of what he did driving here that ended up with this accident. So it doesn't seem to have any extra verbiage that would allow it to be treated as the same as prong two.
Well, the state and this morning was very focused on the term but for. And we're not, and this is not but for was, we just distinguish ourselves when we adopted the code from but for.
That's still part of the statute, right? That's the first principal part of the statute. 2(3)(a)(1) it is antecedent but for which the result in question would not have occurred. Are you saying they don't have to satisfy that standard?
But there's more to it.
Sure. But
And
that's still part of it. So do you concede that portion?
well, absolutely, there's more than a but for requirement. Because you could have absurd results where a madman comes into the hospital and starts shooting patients.
That's
and
an intervening cause.
Right, and but for him, the accident, the person would not have been at the hospital. And the way the state argued this morning is, but for she wouldn't have been in the hospital. And the states have the position that they only have to prove but for, and any subsequent death that falls in the chain is related to the accident.
It's a little bit more than that, but let's come back to the concession that the state made in its argument. They said, we're prosecuting under prong one, but that if death resulted solely from an intervening cause, they wouldn't be able to prevail. Do you agree with that construct?
I don't agree with the word solely.
Okay, but you agree that there could be a theory of prosecution under prong one that allows for an intervening cause as the cause of death to negate the prosecution's efforts, right?
Again, Your Honor, and I think, as I said, I think the facts dictate how a case is prosecuted, defended.
Let's get to the facts in a minute. That's my next question. I just want to understand your standard because it seemed like you were arguing this is a prong two case, which the state is not proceeding under.
Well, the state's proceeding under prong one, and prong one is
You're
whether,
saying if they fail on prong one, the defendant would just be acquitted, correct?
yes,
That's why I don't understand why you're trying to argue against prong one. If they fail under prong one, the defendant is simply acquitted. So don't you have to fit your argument into why they should fail under prong one?
yes, and the reason, and I guess the point is, as far as the defense, is there's still question of whether this was a fatal accident. And if we cannot,
And
and
the
if-
way that fits into the statute is it says that you consider whether the actual result is within the risk of which the actor is aware. I assume you're arguing something about the level of generality about the actual result. So it's one thing to say any death, and it's another thing to say a death that is caused if the person, when they get to the hospital, steals the narcotics and ingests them, then presumably that death, even though it occurred after the accident, is not an actual result within the risk of which the actor was aware.
right, and I'm just, and I'm just quoting Buckley, for prong one, it's whether the defendant was aware that his conduct gave rise to a fatal motor vehicle accident. And the question under a prong one prosecution in this case is whether or not it was a fatal motor vehicle accident.
So Mr. Hughes-Devinis got up this morning and explained that there was a consult that took place at around midnight where it was discussed that intubation was needed. And that was declined by that it was needed as a result of the accident. What's your response to that?
There's still question about whether or not she could have survived the crash.
But that's a, oh, you're right.
Right, right.
That's a different question. Do you contest that if there was a determination that intubation was needed, that was due to the accident?
If intubation was,
Are you suggesting that that morning before she ventured out in the car and had this terrible accident, that intubation was needed then?
well, Your Honor, the pulmonary distress was caused as a result after they started increasing the morphine doses.
So that seems like the same factual disagreement we were trying to get at before.
Yes.
You say that there was no consult at 11:30 about her needing intubation as, in the Chief Justice's words, as a result of the accident. You say she only needed intubation because she was given this excessive dose of narcotics, and that's what caused her to need intubation? Is that what you're arguing?
Yes, and Dr.
Go ahead.
I was gonna say, and Dr. Velez is ready to testify to that. That's in his report, and he's ready to testify to that. Again,
I
if we
didn't
have,
see that specifically in his report.
I have it marked at page 311, where he says vital signs remained stable throughout her brief hospitalization, and it was only until opioid dosages were escalated as she was admitted to hospice at the wishes of her family that respiratory depression ensued, not as a result of her rib fractures, however, due to the use of opioids with the unknown complication of respiratory depression and hypoxia.
That was the next day already, no? I thought that was like right around the time she was dying at about 5 p.m. the next day. And we're talking about the day before.
Does he cite 369A?
Now,
That
I'm reading, he
proposition?
is referring to Dr. Khan's testimony. He said that Dr. Khan testified that the decedent's prognosis was poor due to multiple rib fractures. However, he says, again, if one looks at the decedent's hospital record, despite an overstated poor prognosis, vital signs remain stable throughout her brief hospitalization, and it was only, and then he continued about,
Was she ever admitted to hospice?
I think she was being admitted, and that may have been at the time that she,
He's talking about an event that happened after she was admitted to hospice. And my understanding of it was that she never was admitted to hospice.
from my recollection of the record, she was admitted, which allowed them to then, if I'm correct, hospice care is what allows them to go even above certain maximums of palliative care with opioids. So instead of, I don't know the exact thresholds, but I think
She was still in the same place.
yes, but I think from one unit to a different unit or different levels of care. But if I'm correct, her
I think what we're hearing from your adversary is that she did not go to a different unit. She didn't go to a different building. She didn't go anywhere because events overtook those efforts.
right, and in the again, palliative care versus hospice care is just a different level of care. Once you're marked, it doesn't require that that you actually be moved to a different facility. So, because I think once she was marked for hospice, that's what allowed them to then give the huge doses of morphine and Dilaudid. and which, we know the result of that, especially, Dilaudid's like, 80 times stronger than morphine. So, but those steps were taken, and the doses were quite short timeframes. I imagine at that point, it must have been a hospice categorization.
Counsel, is there any need for a 104 hearing in this case?
Your Honor, I think based on the just looking at the reports themselves and that the fact that the cause of death is in dispute, I don't think that there is a need for a 104 hearing. I think this court can remand it back to the trial court without the need and for us to put on this defense. Again, Your Honor,
You're saying because there's a dispute, there's no need for a Rule 104 hearing?
as far as relevancy, if based on the reports themselves, since there is a dispute as to cause of death, if there was another purpose for the 104 hearing, but if it's as far as relevancy, I think that certainly the doctors are relevant to this case. Again, under the state's theory, we must accept the state's experts we can't even challenge the state's experts. And I've never had a case where any adversary is able to serve an expert report on cause of death or what be it, and that the defense doesn't get to challenge the expert for whatever reason it is.
Does the state have experts?
The medical examiner is always qualified an expert, and the treating physician, I know the case law, at least in the civil context, allows, I know that it allows for treating physicians to be qualified as experts, and that the state saying how, they're saying how they were treating physicians, therefore, but the law has always favored independent experts over treating physicians to testify as experts because of the fact that they may be a fact witness. However, that's really not the issue before us or before this court this afternoon. But the state, I imagine, would be qualifying at least two experts in this case, one being the medical examiner. And under the state's theory, I couldn't even cross-examine the medical examiner.
Could I just ask you to clarify one point? Is it your position that if you were allowed to call expert witnesses, that you will be responding and defending under prong one? Or is it your position that you would be calling those experts to raise a question whether or not the court should instruct the jury as to prong two?
This is a question because, as I said, the facts dictate the case, and the evidence dictates the jury charge. And in this case, the issue is whether we could look at it one of two ways, whether what was her cause of death, but that kind of dovetails into the same question of whether this was a fatal accident. And under Buckley, as I stated earlier, where the language is whether the defendant was aware that his conduct gave rise to a fatal motor vehicle accident. So the question is, was this a fatal motor vehicle accident? Or using prong two, was the death too remote? And I think that we end up at the same place, potentially, under the facts of this case.
But do you contest the state's right to pick one of the two?
Your Honor, typically, the way, if the defendant puts a case in, we even as not, and I'm just, saying, even if it's not credible, typically the court is required to give the necessary jury charge.
So the reason I don't understand this argument is the way that prong one and prong two are attached are with the words or, comma, if not, comma. And here the state is saying that if you prove or, comma, if not, comma, your client goes free and is fully acquitted. And you are arguing against that and somehow saying that if or, comma, if not, because you only get to prong two if you have disproved prong one because of the words or, comma, if not, comma. So you seem to be saying, even if at trial you disprove prong one, you then also want to have to disprove prong two instead of having your client acquitted.
See-
I'm not looking at Buckley or I'm looking at the statute. Where in the statute does it say anything to support your argument?
Let me just pull up. Well, Your Honor, the way that the statute, because in the part two of the statute, it talks about whether it's too remote and it's
But
occurrence.
you only
volition.
get to that if it has to be either within the risk of which the actor is aware, or comma, if not, blah, blah, blah.
Right.
So here they're saying, if you prove that it was not within the risk of which the actor is aware, your client is just acquitted. And yet you seem to not want that. You can't get to the true remote unless you first prove that it is not within the risk of which the actor is aware.
But Your Honor, and if because under Buckley, if the risk is that he could be, that anyone, that the risk perceived was that could be in a fatal motor vehicle accident. And I can't put on an expert to say this was not a fatal motor vehicle accident.
But shouldn't you be saying, yes, you can put on that expert in prong one to say this was not within the risk of which the actor is aware?
But again, maybe we're saying the same thing different ways, because if I'm saying, because they're going to go to the jury and argue, she died as a result of this accident, and he was aware that his driving could result in a fatal motor vehicle accident. That's how they're going to sum up. And if I can't even put on an expert to say she died as a different result, or then it's not, then, you know, my ability to put on my defense, I can't do anything to.
Why can't you put on an expert to say she did not die as a result of your client's conduct?
That's what our experts are saying, that she died as a result of something else. And their view is that we can't put on experts. Their position is that I can't put on any doctors to contest cause of death. Because that was my point about, you know, whether it's prong one or prong two, I think we get to the same place, because at the end of the day, they want us to know, their argument is that I don't get to put on any expert. That, because to Your Honor's point, yeah, I can't even say that the result of, according to the state, I can't have an expert to testify to anything, not even that she died as a result of something other than the car accident. That, you know, this happened at the hospital, she had this condition, this, and this happened at the hospital. According to the state, we don't get that far. I have to take their medical examiner, strike that. The jury has to take their medical examiner at their word. And I can't do a thing about it. Under the state, if the state had it their way, I wouldn't even be allowed to cross-examine their expert, because under their theory, I can't do anything to contest death. That's how they view this case. If I can't put on an expert to contest if I can't put on my own expert to contest theirs, can I even cross-examine?
If we're making this more complicated than it
I
needs to
think
be.
we are.
And you'll tell me if this is wrong, but flip it around. Supposing the state says, we're prosecuting on the basis of prong one. And if we prevail, there's no need for you to negate prong two. Fair?
Oh, I agree with that.
Isn't your argument then, we want to enter into the debate about prong one by showing this palliative care was an intervening cause?
Your Honor, as long as I can put my expert on to say this was not a fatal accident, or she died as a result of something other than the accident.
So help us fit that. We understand what you want to do. Fit that into the statute with the parameters that we've been discussing.
With the actual risk, if the actual risk is fatal accident,
The actual result.
or results, strike that. If the actual result is fatal accident, then, you know, applying a prong one, or applying with a prong one jury charge and a prong one prosecution, under the state's theory, we are not able to put on an expert to say that causation was, or that the death was caused by something other than the accident.
And why can't you argue that the palliative care was an intervening cause?
Because I wouldn't have anyone to testify to that.
Why couldn't you introduce, what if you were permitted to introduce a witness? Could you make that argument?
Well, if I couldn't qualify an expert, they have someone, well, number one, they would have someone testifying as an expert. And I think, and for someone to come in and testify that the death was as a result of something other than, is 100% would definitely be expert opinion. I don't think a layperson would be qualified, or someone who's not qualified as an expert witness.
And represented to us that you do have experts who would say the cause of death here was not the accident, but it was a different cause?
Yes,
And so that would fit into the actual result not being within the risk of which the actor was aware, because the person died not as a result of the accident, but as a result of something else. That's what we've all just been asking.
yes, absolutely. And I'm just trying to say that under they don't think we get a right to make that defense.
Okay, you're saying you should be able to introduce the experts under prong one if the state wants to prosecute under prong one.
Yes, and the reason I think it fits into that is because of the death, because causation is always an issue. Otherwise, and if the risk is fatal accident, there's question of whether this was a fatal accident.
But if the facts demonstrated to the trial judge, the gatekeeper, that the decision not to proceed to full intubation, consistent with the DNR, was the natural result of the accident and what led up to that consultation at midnight, do you still have an argument?
Yes, because there's still arguments about whether she would have survived, or whether she would have died as a result of the accident or something else. And whether the cause of death was the accident. If their argument is that it was that that was the natural chain of events, using the language from Pelham, I think that's still expert testimony, that we could have two differing experts, and it's up for the jury to determine which expert they find more credible.
So in the case of, let's simplify the construct for a second. Very serious accident leading, like the one here, leading to very serious injuries. Victim is hospitalized, and a couple of hours afterward, the doctors say, we've got to intubate this person, otherwise they're not going to survive. Where are you then?
If a doctor was to opine that she would not have, well, it depends, Your Honor, because if I had an expert that was able to contest that, or who was of the opinion that she was able to survive, maybe the autopsy showed injuries, maybe they were under the impression that there was injuries but when they actually did the autopsy, those injuries were not there, or whatever it may be. So if there's an expert that's able to testify differently, then I think, again, the defense has every right to contest the expert testimony that the state puts up.
Other questions, anyone?
I just have a brief one. If she was receiving morphine to deal with her pain, and that morphine facilitated or exacerbated the need to be intubated, and there was not an issue about an extra morphine push when in palliative care, but if she'd been receiving morphine affected her breathing that required intubation, that's all the fact pattern we'd have. You'd be in a much weaker position right now, wouldn't you?
Absolutely, but according to Dr. Velez's report, her vitals remain stable until the increase in the opioids. So that's, as I've said numerous times, it's the facts that dictate where we end up in this case. And based on the facts, again, under Your Honor's hypothetical, I don't even know, maybe there's not an expert in the world who would be helpful for me. But again, we have medical records and that say one thing, and an expert who is able to contest the state's proofs in this case. So again, that's why I've said numerous times, it's, the facts dictate, the way that they prosecute and the way that we defend cases. So I don't think that's any secret.
Thank you, Mr. Feinberg.
Thank you, Your Honors.
Ms. Mackes?
Good afternoon, Your Honors, and may it please the court. I want to pick up on two themes that were discussed a lot with defense counsel. The first is clarifying how this statute might work with sets of facts that seem to fall in the middle of these two prongs and how those prongs don't conflate into each other, and then also the issue with intubation. But of course, I'll answer any questions along the way. The statute clearly requires the jury to determine if the actual result was within the risk result, which requires a comparison between these two things, the risk result and the actual result. Now, Martin on pages 12 to 13 tells us that to conduct that comparison for prong one, the jury has to determine if the actual result is of the same character and manner as the risk result. Prong two, alternatively, is met if the actual result is of the same character but occurred in a different manner than the risk result. So prong one requires information on manner of occurrence, how this person died, and character of the actual result, which is the injury here, indisputably death. And this maps on very clearly with the statute because, to Justice Weiner-Apter's point, prong two requires the actual result to involve the same kind of injury or harm as the probable result, and then also it not be too remote or dependent on another's volitional act. But that language is preceded by the words "or if not." So we know that prong one can't just mean that the risk result and the actual result involve the same injury, because then we would never get to prong two. The first part of prong two would be answered by prong one, it'd be written out of the statute entirely. And that's also really supported by the final report on page 50, the final legislative report, excuse me, where it explains that how somebody died is relevant to these prongs, as well as the model penal code on pages 261 and 266.
Sorry, can you say that one more time? Final legislative report, page 50.
Yeah, 49 to 51 is all relevant, but page 50 I think can be particularly instructive on this last point.
And then the model penal code, what?
In the model penal code on page 266, the commentary reads that the term actual result as it occurs in subsections 2 and 3 is meant to be contrasted with the designed or contemplated or the probable result in terms of its specific character and manner of occurrence. And then there's also helpful language on page 261 that talks about how prong two is about the same injury, but that occurred in a different way, implying that prong one would have to be the same injury that occurred in the same way.
Does the state have the right to select whether it is a prong one or a prong two prosecution?
That's certainly the law in the state. That is what Buckley makes clear. The Office of the Public Defender isn't challenging that at this point. I mean, I think there's reasons why that could be troubling with the language of the statute, because I think it most logically reads as like a 1-2 step for the state. If they can't prove prong one, then they could try to prove prong two. But to Justice Weiner-Apter's point as well, that's not necessarily beneficial to the defense. And if the state can't prove prong one and chooses not to proceed on prong two, then they have the right to make that strategy call.
And does the public defender have a position as to when that declaration should be made known?
So as stated in our brief, we think that declaration should be made known at the time of the pretrial conference so that the defense has the opportunity to retain an expert that will be on point and do the investigation they need to do. I will say, I think that point is far more important if this court adopts the state's understanding of prong one. Because the state's understanding of prong one means that no evidence that can show how this person died, the main fact that we would need those experts to investigate, are relevant. And so that is where you could see a defense attorney wasting ample time and resources on an expert that could never be relevant. I don't think that's how prong one can or should be understood, but I think it's when the notice requirement becomes most significant. And just to sort of use some hypotheticals or a hypothetical to talk about how these prongs don't collapse into each other, I think they can be muddied because often similar evidence is relevant to both inquiries. So for example, if you have a reckless driver who veers off the road and causes a serious head injury in the victim, and then on the way into the hospital, the paramedics drop the victim off the stretcher and they hit their head again and soon after die. In that case, if the state pursued prong one, the jury would have to decide, was that death caused by the accident? Was it caused by the EMT's mistake? And all of that evidence would be relevant to determining, was the actual result in this case, whatever it may be, within the risk of reckless driving. And the jury might find that, yes, the initial head injury based on the state's experts caused the death. It may find that the second injury caused the death based on the defense experts, and that could take this case out of prong one. And then if the state decided to pursue prong two, that same evidence would be relevant to establishing an intervening cause. And so I think the prongs get muddied because this evidence is relevant often to the question of how this person died, which is a necessary question under prong one. And it's also relevant to remoteness, intervening causes, accidents under prong two. Different inquiries, but similar facts. And in this case is similar to the head injury hypothetical that I discussed because there is a dispute about how this victim died. Is this a case like Buckley where the defendant's reckless driving caused a death, or is it something else? And the defense needs to have the opportunity to dispute that causation. I next want to touch on the intubation issue. My understanding of the record, and is that there was a conversation clarifying that Ms. Millie had a DNR DNI on page 369 of the state's appendix and page 32 of the defense appendix. It says that she has an advance directive and that it was reviewed and validated by the patient and the order given for DNR DNI. It's not clear to me from that record, and I don't think it's clear from any other place in the medical records, that there was a conclusion that she required intubation and refused it. There was a clarification that she had a DNR DNI in place should that moment come to fruition.
Was there anything else in the record about her requiring intubation based on the injuries and not based on the level of narcotics given once she was moved to palliative care?
Not that I've seen, Your Honor. And I would point out that throughout the record, there are several times where her breathing is characterized as spontaneous, normal, unlabored, no acute respiratory distress, airways open, lungs clear, nasal cannula only as needed. I can list the appendix numbers if Your Honors are interested, but it's certainly at least disputed the extent to which her breathing was a problem at minimum. And since there is that dispute in the record, since there's something for the experts to base this opinion off of, I think it is extraordinarily relevant to the question of how Ms. Melee died.
Do you read the record as Ms. Melee participating in the decision to go to palliative care?
I think on the discussion about her decision to go to palliative care, I believe happens on defense appendix page 61, state appendix page 398. All it says is that family wants palliative care. There is several points in the medical records where Ms. Melee is described as confused. I think there's a point.
Can you say the state appendix page one more time? I'm sorry.
I'm sorry, I'm a fast talker. 398. There's a point, I believe, and it's not jumping off the page for me right now. Oh, here on defense appendix 66, state appendix 403. This is after she goes to palliative care, but the nurse notes that she appears to be confused. And when she asked who her son was, she told us he was her husband. So clearly her mental state is not extraordinarily lucid at times, but I don't think it's entirely clear from the record the extent to which she participated in that conversation. I also, and actually to add one more thing to that, regardless of the time that she was intubated, I think this evidence would still be relevant. If she had been intubated because of the injury she suffered in the crash, the opinion that she wasn't intubated because of the injuries she suffered
She wasn't intubated, so I think their argument is just that she needed to be intubated because of the crash, and it is her right to choose not to be intubated, and that does not lead to any break in causation or anything related to causation.
That is the argument the state would make, and the defense would have the opportunity to dispute that argument. And any argument that, actually that's an incorrect reading of her medical records, she didn't actually require intubation, that would be relevant. It might not be reliable, it might be a net opinion, there might be other evidentiary bars to that evidence, but the question before this court today is whether this evidence is relevant under Rule 401. and evidence that goes to how Ms. Melee died or whether she rejected intubation, etc., will certainly be relevant to prong one's question of whether the manner and character of her death was within the risk result of the defendant's reckless driving.
Did any of the experts testify as to whether Miss Melee would have regained a meaningful quality of life?
Whether she would, are you asking if she would like go back to the life that she had been living previously to the accident?
Asking a very specific question based upon quoted language from the directive. Any of the experts testify as to whether Miss Melee would have regained a meaningful quality of life?
So Dr. Bellas testifies that she would have survived. I don't think he speaks directly to quality of life. And both of the experts draw upon the language from the palliative care nurse who states that regardless of whether she survived her injury, she had been, quote, demented for some time. That's the extent of information in the record I'm aware of that would answer your question.
So is regaining as your understanding of the concept of regaining a meaningful quality of life, would that be akin to regaining the quality of life that she had pre-accident?
I think so, Your Honor, but I also think this would, the questions you're asking would still put us in a, in fact, question for the jury land. And so these are questions the jury would be able to answer. The parties would be able to make arguments as to whether she could have returned to that quality of life or not, whether the intubation or the execution of the DNR, DNI, the choice for palliative care, the removal of life support, what have you, was necessary. Those are all still relevant questions that the parties can speak to. And then the jury can determine the fact question. Was the actual result of what happened here, its manner and character, within the risk of reckless driving?
If none of the experts speak to that question, who would be speaking for the question? Whether she would have regained a meaningful quality of life?
It seems like an expert would have to testify to that question just from a medical perspective.
But they don't.
I don't think that question is necessary to resolving the issue in front of us right now. So because Martin makes so clear that prong one is asking about the manner and character of death, the question here is how she died. If she died because of the narcotics given to her while she was in the palliative care unit as a result of her Alzheimer's, then that might not be within the risk of reckless driving. And if she died in some other way, the jury is still going to have to determine how did she die, and is that death within the risk?
Is it your contention that she was in the palliative care unit because of Alzheimer's?
Yes, that is my contention. And in the record, well, actually,
It had
my
nothing to
contention
do,
is
it had
that
nothing to do with, she wasn't in the palliative care unit because of what we heard earlier today was 14 rib fractures?
allow me to amend my answer. My answer is that I think it's a dispute that the jury has to decide. The state says she was in palliative care because of the injuries. The defense says she was in palliative care because she had terminal Alzheimer's and other comorbidities. And the jury will determine which of those things are true, because that will inform the manner of her death, the way that she died. And then they'll have to answer the secondary question under prong one, which is, was that actual result within the risk of reckless driving? And I don't think, any of these arguments go to the weight of that testimony. The jury might say, absolutely not buying it. But if the question is relevance, that opinion testimony is certainly relevant to the issue at
Is
hand.
that because,
Sorry.
Go ahead. Go ahead. Is that because Dr. Leffers found that Miss Melee's injuries, quote, taken together with her pre-existing condition were life-threatening? That a statement like that the phrase taken together, we just don't know what that means. We have to understand what taken together means in the context of how that's balanced.
I think that will be a relevant question to ask Dr. Polamini on the stand, what he meant by that.
I think it's Dr. Leffers.
Oh, I'm sorry, Dr. Leffers, I apologize. we do need to know what that means, and if the state can provide Dr. Leffers to say that she died more because of the accident than because of these comorbidities, then certainly the defense has to be able to refute that with an opinion that she died because of the Alzheimer's and not because of the accident. And so regardless of where this nets out, if the jury believes Dr. Leffers, if Dr. Leffers elaborates on that point to convince the jury that it was actually the car crash that caused her death, the defense opinions here that those injuries were not fatal, that they did not contribute to the decision for palliative care, and that she died ultimately because the narcotics given to her in the palliative care unit would still be relevant and should be admissible under 104. Whether or not it's admissible for other reasons is a question for another day.
That was my question. Does OPD have a position on whether or not a 104 hearing is a requirement here before this could be admitted?
OPD's position is that a 104 hearing is certainly not required on the issue of relevance. These expert opinions are facially relevant to the prong 1 question. I think they're also relevant to the prong 2 question, had the state decided to prosecute under prong 2. I also would clarify that the appellate division's point that inconsistency in the defense experts is grounds for a 104 hearing is incorrect. The defense is always able and permitted to put forth alternative defenses. And to the extent that these experts even disagree, I think those disagreements are pretty immaterial. So we don't believe a 104 hearing is necessary for relevance or for inconsistency, but if the court finds that a 104 hearing is appropriate under Rule 702 or 703, OPD has no position on that.
Anything else you'd like to add, counsel?
No, thank you.
Thank you. Mr. Brady, brief rebuttal.
Thank you very much, Your Honor.
The reason the victim received palliative care is because she chose it. It's not a medical opinion. It was her personal choice.
And where on the record are you looking to say that she chose palliative care? Where we have find that definitively from the record?
Well, what we look at is PA 357, 364, 367, PA 369.
Sorry, can you say
Slow
that a
down.
tiny bit
Slow
slower?
down and do it
Yes.
again.
So essentially, you just read through the medical records.
No,
To
can you
give us the
cite
sites.
them?
Yes. PA 357, PA 364, PA 367, PA 369, PA 390, as well as Dr. Khan's testimony as a fact witness, 6T 46 to 11 to 48 to 10, as well as 6T 52 11 to 5310. Dr. Khan testified for the reason why the Mealy family chose palliative care. The reason was, as Dr. Khan explained, that this victim had no chance of survival because of the blunt trauma that she endured.
Is there a place in the record, coming back to the questions before we broke, that speak to her needing intubation in order to survive? And
Yes.
that the decision about palliative care followed that?
Yes, thank you. Excuse me. 6T 46 to 11 to 4810, same site. And again, 6T 52 to 11 to 5310, as well as 5T 5114.
I'm sorry, the next, you said 6T and there was a second 6T.
Yes, the second 6T is 52 line 11 to page 53 line 10.
And this is Dr. Khan's testimony testifying to the fact that she needed intubation before palliative care. was
That's exactly
initiated.
right. That the palliative care was chosen.
Sorry, can you say the 5T one?
Yes, the 5T, page 51, line 14 to page 52, line 4. It's a factual question. The family, Miss Mealy, they chose palliative care because it's what they wanted, not subject to some doctor saying, you have to do this because it's my opinion. It was a personal choice. And that's what the state of New Jersey wants. It wants people to have this self-determination to make their own choices.
Put aside the family's legitimate right to make a determination and assume that it made that determination appropriately. You're telling us there's a place in the record where we're going to find this individual needed intubation in order to survive.
Absolutely. The doctor, the treating physician testified explicitly about it. Also, the advanced directive where it talks about the quality of life, that's not subject to doctor's opinion either. Quality of life that Miss Mealy wanted, it's what she got to choose to do. She didn't have to endure someone sticking a tube down her throat. And I want to talk about the differences with Pelham. So Pelham is, like the AG indicated, it's pretty controlling in this case, not because it's talking about how to prosecute or defend a prong one. It's because it's saying that the expected foreseeable care, the palliative care that Ms. Mealy received is foreseeable. It takes it out of any intervening cause. It is not an intervening cause. What controls whether or not this is a prong one or prong two is whether or not the actual harm was within that was risked. But still, the state also disputes this characterization by the defense that Ms. Mealy was receiving large doses of anything. She received minimal amount of morphine in order to make her comfortable. And in fact, as it was explained by the doctors, the pain medication actually reduces the pain so that a victim can try to take those deeper breaths, to get more oxygen in, to cure that reduced oxygenation that was leading to her death. The fact of the matter is, if Miss Mealy was left roadside, she would have died faster. She wasn't. She received some care. And then she said, enough of that care. Her and her family have that right. The interesting thing about the defense saying, I think it was Palomini who says, oh, taken together, that these things may rise to an intervening cause. Well, taken together, that means it's not solely attributable. That means it is not an intervening cause. More so, again, back to Pelham. Pelham was a case in which the victim sustained severe injuries relative to the crash, just like in this case. But different from this case, they did stick the tube down the throat. And then there was a subsequent act of another. Someone took the tube out. In this case, no one put the tube in. So there's even less action in this case than that which was described in Pelham. And relative to Martin, that case addresses but-for causation. And that which the defendant's conduct contemplated and what he would be responsible for. There is no intervening cause in this case. And in fact, the intervening cause proffered by the defense is proscribed as a matter of law, not to be an intervening cause. The defense repeatedly says the state doesn't want them to proffer any experts. It's just not true. Prior to the first trial, defense counsel called me and said, I have some experts I think you're interested in. The state was interested. Then after reading the report and recognizing that as a matter of law, that is not an intervening cause, the state wasn't interested so much anymore in what they had to say. If they come forward with an expert that says that this risk wasn't within that it was contemplated, the state's interested to know. If they come forward and say that prong one culpability, that this type of something happened in between, the state is interested to know. But receiving the expected comfort care that she received, that's not unforeseeable. As a matter of law, it is not an intervening cause. They haven't proffered anything relative to but for.
Is there
prong
any
one.
rule for an intervening cause in prong one?
Yes, I thought Justice Radner pointed it out excellently, where under a prong one case, yeah, there might be an intervening cause, which would say that this is no longer a foreseeable consequence.
I appreciate the compliment, but I was quoting your argument.
Well, I guess I understand why I liked it so much. And I like it so much because it follows the law. There's no need for any of this speculation as to what could have been or what should have been or what may have been. We have the law to follow. And that's why the state is asking that you go along with it. They say, oh, the state can present any experts they want. The state's not presenting any experts. It does have fact witnesses who are experts, But those fact witnesses aren't talking about expert opinions. They're just saying what they saw. They're saying the family decided to have palliative care because of the injuries. And I only presented Dr. Khan because the initial trial court didn't grant my motion to preclude and said, we'll hold it open for hearings at the time of trial. Well, after a month of trial, after the state's presented its case, it was only at that time that the defense says, oh, our experts are going to say that the family murdered.
Is the state prepared to call a medical examiner in this case as an expert?
The state is prepared to call the medical examiner. Yes, they'll be qualified as an expert, but they are not retained for the purposes of litigation. And they do have fact testimony relative to what she saw. She will say blunt injuries. And whether or not that is the cause of death, well, we'll look towards the legal standard as to whether or not that death is something the defendant can be held culpable for. We look to but for. We look to the culpability
So
test.
is the state, will the medical examiner give an opinion with respect to causation, to the cause of death?
In this case, the state's, at the initial trial, the state did not elicit that testimony. However, on the defense's cross-examination, they got exactly what they were looking for.
Which was?
That the
Judge
crash
resolved the
called the
accident.
death, unequivocally. Not only unequivocally by Dr. Khan, but by Dr. Leffers, but then Dr. Khan came and said the same thing. Now they're saying, Dr. Remolina says that, that it was chosen for the Alzheimer's care. It's just not. It's not in the record. They say the decision was made because of Alzheimer's, but it wasn't. And the point that they cite to, I think it's PA 390, basically contemplates the comorbidities. There's nothing strange about that. Again, the independent cause that they allege, it needs to be the death needs to be solely attributable to that, not a confluence taken all together.
But that's what Dr. Leffers said, taken together. That's what Dr. Leffers testified to in the 104 hearing. Taken together with her pre-existing condition were life-threatening.
That's exactly right, Your Honor. Taken together, not independent, not solely, not just the intervening cause. They're talking about what this person, take your victim as you find them.
We don't really know what role each played, right?
We know that,
We just know they were taken together.
no, I mean, it's pretty, if you read through the medical reports, it's the medical records, it's pretty obvious that the comorbidities were a mere consideration as to what quality of life she would receive after, if they were to give her the care she didn't want.
Counsel, can you wrap up your argument, please?
Yes, I think it's also important to note that defense notes that the CT scans only showed 3 rib fractures. And they say that it didn't have any bruising because the autopsy report didn't reveal bruising. Well, the CT scans looks at layers of imaging throughout the body. They were able to recognize 3 in the picture, but once they cut Miss Mealy open, lo and behold, they're seeing 14. And lo and behold, they can't see through the tissue that which they see in the CT scan was bruised. So Dr. Leffers doesn't see bruising on the exterior of the lungs, but that's not to say that it's dispositive relative to whether or not there was bruise. And in fact, when they take the CT, there's more than one CT scan. There's one in the beginning of the treatment and one a little bit later. Comparing those two, it is unequivocal that there is a deterioration in the lungs and that bruising is materializing. The fact of the matter is, if defense wants to rebut the allegation that she received palliative care for any other reason, they're going to need a fact witness to testify about that. They don't have one. It's not a matter of medical opinion as to why she received the care she did. She got it because she wanted it. She got it because she didn't believe that she had any more life to live in the quality that she wanted. And that's not a matter of opinion.
Thank you, Ken. Thank you to all counsel. We will take the matter under advisement.